morning, this is your Kelso Report for Tuesday, September 11th, and I'm your host, Clark Kelso. Our topics today include how to group criminal charges for purposes of sentencing, how to identify sham declarations, the impact of legislative immunity and qualified immunity in two lawsuits, and how to select the appropriate interest rate in a case involving the return of seized currency. We begin with the Ninth Circuit and grouping of criminal charges. Sentencing under the federal sentencing guidelines is an extremely complex undertaking. Now, just one of the scores of issues a court must consider in sentencing is the question of how to group multiple charges against a defendant convicted of multiple crimes. In United States v. Wilson, the government and the district court grouped all 9 counts into a single group, reasoning that all of the counts involved one overall scheme to defraud. The 9 counts included 3 counts of wire fraud, 2 counts of possession of an unregistered firearm, and 1 count each of extortion, making a false statement, destruction of a letterbox, and possession of a firearm not identified by a serial number. The defendant argued, and the Ninth Circuit agreed, that it was error to group the mailbox offense and the wire fraud and extortion offenses together with the remaining counts, since those 3 counts involved crimes against a different victim. Sentencing Guidelines Section 3D1.2 provides that for purposes of sentencing, all counts involving substantially the same harm shall be grouped together into a single group. Well, the Ninth Circuit held that this language, in the reference to the same harm, meant that the grouped counts must involve the same direct victim. Since they didn't, the court had committed a sentencing error. Next, we turn to sham declarations. There is unfortunately a marked tendency in our justice system to treat litigation like a game. Truth can quickly become a casualty as parties on both sides try to present just enough information to move the case forward to the next stage, ultimately hopeful that if they can just get before a jury, persuasive performances by counsel will win the day. In Yeager v. Boland, however, the Ninth Circuit stopped the shenanigans at an early stage. Famed test pilot Chuck Yeager brought suit against the defendants, who were commercial retailers in the business of selling aviator-related memorabilia. He sued for violations of the Lanham Act, breach of the common law right to privacy, and breach of the right of publicity. At his deposition, in preparation for a defense motion for summary judgment, Yeager claimed that he did not remember answers to over 180 questions, many of which were about relatively recent events. Subsequently, at the same time his counsel filed his brief in response to the motion for summary judgment, he filed a written declaration containing comprehensive details that he did not remember at his deposition. The district court struck the declaration under the sham declaration doctrine, pursuant to which a declaration generally may not materially contradict prior deposition testimony from the declarant. The rule is designed to prevent gamesmanship and abrupt changes in the declarant's testimony. The Ninth Circuit on Appeal agreed with the district court. According to the district court, the deponent remembered almost nothing about the events central to the case during his deposition, but suddenly recalled those same events with perfect clarity in his declaration in opposition to summary judgment, without any credible explanation as to how his recollection was refreshed. The fact that Yeager did not directly contradict his deposition testimony, which was filled with gaps, and instead simply provided information which he previously claimed he could not remember, was no defense for Yeager. The declaration smelled of sandbagging and gamesmanship, and it was struck. The Ninth Circuit affirmed summary judgment in favor of the defendants. Now we have 2 suits involving sovereign immunity and doctrines of absolute and qualified immunity. The doctrine of sovereign immunity remains a potent defense against liability, even in cases where it appears the plaintiff really has unfairly been given the short end of the stick. In Schmidt versus Contra Costa County, the plaintiff was a temporary Superior Court commissioner who decided to run against an incumbent judge in 2004 in the election. Well, she lost the challenge, and shortly thereafter the Superior Court's Executive Committee adopted a policy rendering her ineligible to continue to serve as a temporary commissioner. What a coincidence. Having lost the election and her position as a temporary commissioner, she filed a Section 1983 suit in federal court, claiming that the Executive Committee had adopted its policy in retaliation for her challenge to the incumbent judge, in violation of her free speech rights under the First Amendment and the California Constitution. The Ninth Circuit acknowledged that the timing and targeted effect of the Superior Court's policy change were suspicious. But ultimately, the court held it could not reach the merits of the claims because the judges of the Superior Court's Executive Committee enjoyed legislative immunity for their decision to alter the minimum qualifications to serve as a temporary commissioner. Legislative immunity is a form of absolute immunity, and it is designed to protect legislators from being constantly hounded with lawsuits arising out of action taken by legislative bodies. The Ninth Circuit held that the Executive Committee members were acting in a legislative rule-making capacity when they changed the minimum qualifications. And so they were all protected from the plaintiff's claims by immunity, and the lawsuit was dismissed. Our next case also involves immunity, but this time the doctrine of qualified immunity. This time, with qualified immunity, that's the doctrine that applies to executive branch officials, and in this particular case, to law enforcement authorities. Now, unlike absolute legislative immunity, a qualified immunity can be lost if the official's conduct violates constitutional rights that were clearly established at the time the official acted. Like absolute immunity, the basic purpose of the doctrine is to give executive branch officials broad protection against harassing lawsuits for injuries that result from the government's official duties in doing his or her job. In Mueller versus City of Boise, the issue arose at a hospital emergency room. An infant's mother had brought the infant in because of a high fever and a concern that the infant might be at risk of serious illness or meningitis. When her temperature started spiking upwards, the attending physician decided that the girl needed a full fever workup, including immediate administration of fluids and antibiotics. For reasons that are not clear, the mother at the time refused to consent to the treatment. When the physician explained to a law enforcement officer who was in the emergency room that the infant's life was at stake, the law enforcement officer separated the mother from her daughter and directed the physician to proceed. Now, the law is clear here that the parents have a liberty interest, constitutionally protected, in the care, custody, and control of their child. And this generally means that only parents or a lawful guardian are legally authorized to consent to or refuse to consent to medical treatment. It is also the case, however, that, like all constitutional rights, the parents' rights are not absolute. Under certain circumstances, these rights bow to other countervailing interests and rights. In this case, the basic independent life and liberty rights of the child, and of the state acting as parens patriae in the best interests of the child. As the Supreme Court has said, a state, quote, has an urgent interest in the welfare of the child, close quote. So the question for the Ninth Circuit was, when do the constitutional rights of parents step aside? The answer to the Ninth Circuit panel was clear. In an emergency situation, when the child is subject to immediate or apparent danger or harm. As the panel explained in finding that qualified immunity applied here, this case involves a series of nighttime emergency room judgments and decisions made under pressure about which people might differ. Doctors nowadays, especially in emergency rooms, and police officers face daunting challenges, one of which is state law requiring them to report to state authorities possible child abuse, endangerment, or neglect. Their failure to do so lands them in serious trouble. Also, a doctor's failure to recognize possible meningitis is equally problematic. The Ninth Circuit closed. If anything, the completed record shows that the doctor in this case exercised his best judgment in an emergency setting in favor of ensuring an infant's safety from the very peril that caused her mother to take her to the hospital in the first place. This is hardly the stuff of which a cognizable civil rights violation can be made. Close quote. The officer was protected by qualified immunity and the case was dismissed. Our last case today deals with an issue that frequently arises in the law of remedies, and that is what rate of interest should be used in calculating a claimant's total judgment for property loss. The issue arose in People v. $12,601 in currency, a case where some $10,000 was seized from the defendant's hotel room way back in 2003. The defendant in the underlying criminal proceeding and the claimant in the forfeiture proceeding at issue secured a post-judgment order, finally awarding him $12,601, which represents the $10,000 seized in 2003, plus the interest actually earned on the seized funds while they were on deposit in an interest-bearing account. The defendant appealed, arguing that he should have been awarded interest at the much higher interest rate of 7% per year, as specified in the California Constitution, for interest earned on judgments when the legislature has not specified any other rate of interest. The Second District rejected this argument because the relevant seizure statutes in the Health and Safety Code require that the seizing agency, quote, preserve the value, close quote, of the seized property, which the court interpreted as requiring that the cash be deposited in an interest-bearing account and that the claimant recover the currency plus the interest actually earned, rather than interest at the higher 7% rate specified in the Constitution. According to the court, only by awarding the interest actually earned was the value of the property preserved. That's it for today's Kelso Report. Have a great day in the law.